Good afternoon, students. I hope all of you are doing good and I hope your preparation is going fine. Welcome to today's Analyst. This is 3rd of February 2024 and we are here to discuss important articles from the Hindu and the Indian Express. Now, the handout of the session is there in the description box. You may utilize it to streamline your current affairs preparation. Now, coming to the first topic of today, it is in relation to Foreign Contribution Regulation Act of 1976. The second topic of today is in relation to Uniform Civil Code. Third topic is in relation to multidimensional poverty in India. And fourth topic, last but not the least, is in relation to maritime piracy in India. So coming to the first topic. The first topic is in relation to Foreign Contribution Regulation Act of 1976. Now, why this is news? Because recently Central Bureau of Investigation, CBI, has searched the premises linked to an ex-IS officer in FCRA violation case. Now, this is very crucial and important for us to understand in relation to our Indian polity and Indian economy. Now, coming to FCRA Act of 1976, so Foreign Contribution Regulation Act of 1976. What was the purpose of this act? The purpose of enactment of this FCRA was to regulate foreign contributions by certain individuals or associations to NGOs and others within India. So what's the purpose? The purpose is to regulate any sort of foreign contribution by any individual or association to the NGOs into our country, to the NGOs or different people in our country. That was the main aim of this act. And by the date itself, by the year itself, you will be knowing that it was enacted in 1976. So it was during the emergency period. So it was passed in 1976 and a major amendment to it was done in 2010. So that the 1976 Act was effectively repealed and the new Act of 2010, FCRA 2010, was enacted with major amendments. Right? Now we need to understand what are the aims and objectives of this Foreign Contribution Regulation Act. Now, aim is to prevent foreign organizations from influencing electoral politics in India. Now, recently we have seen that foreign organizations and associations, by funding various NGOs, they halt various environmental projects, they halt various nuclear projects, they halt various infrastructural projects in India, which cause a lot of damage to our GDP. Few years back, a Ministry of Home Affairs report was also suggesting that there was a substantial loss to the GDP of our country because of these foreign contributions which are halting India's progress. So the aim of this FCRA is to prevent these foreign organizations to influence our electoral politics, and also they should not influence our social, political, economic or religious discussion. That is the aim of this FCRA. So this foreign contribution should not be wrongfully impacting our electoral politics, should not be impacting our religious discussions, political discussions, economic discussions, and so on. Okay. And also they should not be influencing these discussions in a way that would be detrimental to the public interest as well. That is the aim of this Foreign Contribution Regulation Act. Now, Ministry of Home Affairs is the nodal ministry under this act, which is responsible for the implementation of this act. Now, we need to understand the term foreign contribution because we understood what is the premise of this FCRA. The premise is to regulate the foreign contribution made by different individuals into India. In respect of various NGOs. But what is this term we are using as foreign contribution? There is a very specific meaning to this foreign contribution under the FCRA of 2010. Because now we know that FCRA of 1976, it was effectively changed to FCRA 2010 in 2010 because of various amendments. So now whatever we are going to study, it is in relation to 2010 only. Okay, so foreign contribution according to FCRA 2010, it can be any donation, delivery or transfer. It can be any donation, delivery or transfer which is done by a foreign source. But in what kind? It can be in the form of articles. It can be in the form of currencies. It can be in the form of securities, which can be your financial securities as well, right? So what is foreign contribution? It is any donation, any delivery or any transfer of article, currency or security by foreign source into India. Now coming to this article, what are articles? Articles are goods, right? So does article include gifts as well? That is the question. But the answer is that article does not include gifts. So the gifts which are given by the foreign source to India, to anyone in India, based on his or her personal usage. And one more condition is there that the market value of the gift should not be more than 1 lakh rupees. If it is more than 1 lakh rupees, then of course it comes under the ambit of FCRA. But if the gift's value is less than 1 lakh rupees, then it is not coming under this article definition of foreign contribution. That is why it will not be regulated by FCRA. So foreign contribution, it includes what? Donation, delivery and transfer of what? Of articles. Or donation, delivery and transfer of different currencies also. It can be your home currency, that is Indian currency, or any foreign currency as well. And also securities, for example, financial instruments. So the delivery, the transfer and donation of different articles, of different currencies, of different securities by any foreign source to any institution or any organization in India, that is what we term as foreign contribution under this FCRA Act. Now, the contribution, there is one specific question which you might ask. Now, the contributions done by NRI. Now, NRI also contributes, right? Non-resident Indians, they are the citizen of India itself, but living abroad. So, NRI rightfully contribute to India. They send remittances into India from their personal savings. Will that be part of foreign contribution? The answer is no. So, the contributions given by Indian citizens living abroad, for example, NRIs, from their personal savings and through normal banking channels, that will be not a part of foreign contribution, because that will be remittances which is given to individuals by the NRIs. I hope that is very clear. So foreign contribution, it includes articles, it includes securities, it includes currencies. It does not include the money contributed by NRIs from their personal savings, through the normal banking channels to India. I hope this is very, very clear to all of you. Now what we need to understand is, under the FCRA Act of 2010, who can receive foreign contributions rightfully? So the Act says that any person can receive foreign contribution provided two conditions are met. First condition is that the person should have a definite cultural, economic, educational, religious or social program. In that case, foreign contribution can be received. And the person must obtain the FCRA registration and or the prior permission from central government. So there are two conditions. First condition is the person should be having a definite cultural, educational, social, economic, religious program. That being met, one more condition is there, that the person must have a registration of FCRA license, or should have taken prior permission from the government of India or the central government. If these two conditions are met, any person can receive foreign contribution. But under this FCRA Act, this term person is also defined. That what do you mean by this term person? Now this term person also includes the individuals like us. This term person will also include your Hindu undivided family. It will also include an association, for example, an NGO, and it will also include a company which is registered under Section 8 of Companies Act 2011, that is your non-profit organizations. So person does not mean just individuals. Person includes individuals, it includes Hindu undivided family, it includes associations, and it includes a Section 8 of the companies registered under the Section 8 of Companies Act, that is your non-profit organizations as well. Individuals or all these associations or companies are part of persons, the term persons. So any one of them can receive foreign contribution provided these two conditions are met. Now one more thing, this FCRA registration of course we need to have, but what is the validity of it? The validity is 5 years. And after the expiry of this 5 years, the NGOs are expected to apply for the renewal within 6 months of the expiry. So after 5 years, within the 6 months of expiry of FCRA license, they need to apply for the renewal of the license. And if the license is cancelled, now the question is, can the license be cancelled? The answer is yes. But in what case? The license can be cancelled if an inquiry is done by the Ministry of Home Affairs, of course, through CBI or any other organization. If the inquiry is done and if it's found that there is some false statement in the application which an NGO gave while getting the FCRA license, if there is any discrepancy in that, and if inquiry is done, in that case the FCRA license stands cancelled. And once it is cancelled, that same organization, that association whose license has been cancelled, they are not eligible for re-registration for the next 3 years. So they are barred from registration for the next 3 years in the case of cancellation of license of any organization under FCRA Act. Now, can this be challenged in any court of law? Yes, this can be challenged in the respective high courts. So, that is in relation to the Foreign Contribution Regulation Act. Now, let us understand the timeline. Of course, we know that in 1976, this FCRA was originally passed, enacted during emergency. Now, what was the purpose? Purpose we all know, to keep a track of foreign influence in social, political, economic, religious decisions. Now, at that point of time, the non-profit organizations, Section 8 companies, they were allowed to freely receive foreign donations while reporting the amount spent and received every year. So they were free to receive any form of foreign contributions. They just had to report that what amount they received and how much they spent. That was in 1976, but in 1984 a major amendment was there, and it was made mandatory for all the non-profits to register themselves before receiving foreign donations. So earlier, they don't have to register themselves. They can just freely submit an application. Okay, this is the money we received. This is the expenditure we made. But in 1984, it was made mandatory for the non-profit organizations as well, that before receiving foreign donations, they have to register themselves. And they cannot pass the fund on to other non-registered NGOs. So those non-profit organizations, earlier what they used to do, they used to receive foreign contribution and they used to distribute it to other non-registered NGOs. But it was barred in this 1984. That means it was said that you can't do so. But in 2010, a major reshuffle happened. So as I told already to you, this 1976 Act, FCRA Act, was repealed and replaced by a stricter Foreign Contribution Regulation Act of 2010. Along with it, Foreign Contribution Regulation Rules of 2011 were also given. Now, in this, the key changes were introduced, of course. Several key changes were introduced. FCRA registration validity was changed. It was permanent earlier, but it was reduced to 5 years. So, right now itself, we saw that 5 years is the validity of registration, right? But it was done in this 2010 itself. Earlier, before 2010, the registration was permanent. After 2010, you had to renew it after every 5 years and was subject to renewal. Also, one more very important fact is that only 50% of the foreign contribution could be used for administrative expenses under this FCRA. And no such provision was there in the 1976 Act. So before 2010 Act, there was no such provision. In this 2010 FCRA Act, it was said that only 50% of the foreign contribution which an NGO is getting could be used for administrative expenses. Now that is also a very, very important point for us to know. And in 2020, recently, 3-4 years back, this FCRA Amendment Bill 2020 came. Now it had broadly redefined terms related to acceptance, transfer, utilization of foreign contributions under the 2010 Act. Now let us see what has been the changes introduced under this 2020 amendment of this FCRA. Now very major set of changes were introduced. Let us understand them one by one. First change was that the public sector employees are now forbidden to receive any foreign contribution. So foreign contribution of any sort cannot be received by the people who are working as public sector employees, that is those who are working in the PSUs. That is first. The transfer of funds. Now, the funds which are received under FCRA by the NGOs, the transfer of the fund received under FCRA to other individuals or organizations is prohibited. So, if you are receiving any contribution from FCRA, from foreign contributions, any foreign contribution you are receiving under FCRA, you can't transfer it now. It is prohibited. Also, the quantum of administrative expenses. We saw that in 2010 Act, it was made to 50%. In this 2020 amendment, it is now reduced to just 20%. So now the NGOs or the organizations can only use 20% of the foreign contribution for administrative expenses. Providing Aadhaar number is mandatory now. So Aadhaar number needs to be provided for all the office bearers, directors and key functionaries of the organization who is receiving foreign contribution. And also the central government is having the power to suspend FCRA registration of any NGO for more than 180 days. So the power to suspend the registration for more than 180 days is vested with the central government. Now coming to the renewal of registration. So renewal of registration after 5 years, of course the tenure still remains 5 years, but renewal after 5 years will be subject to same level of scrutiny as new applicants. Now that is a very, very major change. Same level of scrutiny will be levied on those who are applying for a renewal of FCRA license. That is a very, very important point. Now, all the people or all the persons which we saw in the previous slide, all the persons have to have a designated FCRA account in which they'll be receiving foreign contribution. So, has to be mandatorily created with your State Bank of India, that is SBI. That is also a very important move. And there is also a provision of a voluntary surrendering of FCRA certificate, and it is option available to the non-profits. So that's it in relation to the Foreign Contribution Regulations Act of 1976. Now moving on to the second topic, that is your Uniform Civil Code. Now recently Uniform Civil Code panel have submitted a draft of Uniform Civil Code to Uttarakhand Chief Minister. Now in relation to General Studies Paper 2, Indian Constitution and features of it, especially in the Directive Principles of State Policy, this Uniform Civil Code has been mentioned, and it becomes very, very important for us. Now coming on to the topic of Uniform Civil Code. Now before we understand what is this Uniform Civil Code, we need to appreciate and understand what is a civil code. So civil code refers to the entire body of laws which governs the rights related to property as well as personal matters. So what is a civil code? Civil code are the set of laws which governs the property rights or which governs the personal matters, which can be your marriage, which can be divorce, maintenance, adoption and inheritance of properties. So what is a civil law? What is a civil code? A civil code is a set of laws governing the rights in relation to property, governing the rights in relation to personal matters. Now, what kind of personal matters? For example, your marriage, for example, your divorce, for example, maintenance after divorce, adoption and inheritance of properties. So, the law dealing with all of these things is what we call as civil law. And of course, there is another form of law, that is criminal law. But we are here putting ourselves or discussing only civil law. Now, there are different laws governing these aspects in India. Now, India, of course, is very diverse. Different communities exist in India. So, to govern these different communities based on these civil laws, there are different civil laws that has been enacted. Thus, the law which governs the inheritance or divorce amongst Hindus would be certainly different from those in Christians or Muslims. That is in relation to the personal laws and civil codes. Now, we need to understand what is this term known as Uniform Civil Code. Now, the demand for Uniform Civil Code means what? Why many sections of society are demanding Uniform Civil Code, and why our Prime Minister have also suggested that this country should have a Uniform Civil Code, because there can't be different laws governing members of the same family. So our Prime Minister gave this analogy that there is one single family, and what it would have been for the governance part, that if different members are being governed by different civil laws, would the governance be possible? The Prime Minister asked the public. So that means our Prime Minister is also supporting this Uniform Civil Code. Now, what is this Uniform Civil Code? This Uniform Civil Code essentially means that we are unifying the personal laws which exists. So all the civil codes which exists, unifying them and creating a uniform civil code for all, which is applicable to all the communities, all the religions. To have one set of secular laws, that is not for particular religion, but secular laws dealing with these aspects that will apply to all citizens, everyone, irrespective of their communities or religion. So all the laws in relation to rights to property or personal rights, for example, marriage, this adoption, divorce, maintenance, inheritance, creating a secular law which is applicable to all sections, all communities and all religions in the country. That is what Uniform Civil Code means. Now, what would a Uniform Civil Code look like? Now, this write-up here tells us that if Uniform Civil Code is to be achieved, we need to unify the Hindu personal law as well, the Muslim personal law as well, and the other personal laws which are governing different communities, for example, Christians, Parsis, or other religions and communities. So that is what your Uniform Civil Code, Uniform Civil Law or Uniform Civil Code would look like. Now, what we need to understand is what are the various challenges, that why we have not been able to come up with Uniform Civil Code even after it is mentioned in our Directive Principles of State Policy. So first very big challenge is that it's a colonial remnant. Now colonially, different personal laws have existed in India. And to change that, to reverse that, Till today, it is very, very difficult. And also, some set of experts believe that coming up with this uniform civil code will be a direct contradiction between Article 25 and Article 14 of our Indian Constitution. Because Article 14 guarantees right to equality in our Indian Constitution. Article 25 guarantees right to profess, practice and propagate the religion of their choice to the public of India. Right? So there would be a contradiction between these two laws. Also, there is divergence in different states. For example, many states in our country culturally are patrilineal. But many states in our country, especially the southern states, some of the southern states, they are matrilineal, and the northeastern states as well. Right? So, if a uniform civil code is applied in India, there might be a divergence amongst different states of our country also. And the consensus is difficult. So, over the years, many governments have published various drafts or come up with different suggestions from the public. But the consensus has been very difficult. Because, of course, now we are moving from diversity to uniformity. So, there's a difference between them. India is, of course, a diverse society. But according to many constitutional experts and legal experts as well, having a uniform law for this diverse set of population might create certain problems. So, of course, that remains one of the challenge for implementation of UCC. Also, potential tensions. Now, potential tensions, for example, political tensions or unrests and conflicts in the society, or there can be religious discords, religious conflicts as well, which can hamper the communal harmony in our country. So, keeping all these things in mind, a uniform civil code has not been implemented in India over the last several years, several decades also, because these challenges are still persisting. But there is one specific area or region in our country where this uniform civil code is existing, and that is Goa. Now, Honorable Supreme Court of India has also referred to Goa as a place where uniform civil code is implemented. Now, what does the uniform civil code in Goa what does it look like? So, in Goa, the registration of marriage is compulsory under the Goan code. And any disputes which may arise is resolved only and only by the law, not by the personal laws. And there is a consent of male and female, that is men and women, both is required in terms of marriage. And it also requires prenuptial agreement, which will alter the ratio of distribution of assets. Now, these are the laws which are applicable to each and everyone, irrespective of the community they belong to, irrespective of the religion they belong to. And the property and the wealth owned by each spouse in Goa are equally divided amongst the spouses during the course of the marriage. So they are equally divided during the course of marriage between the spouses. And also in the case of divorce, each spouse is entitled to half of the property. That is a code which is applicable throughout Goa. And in the case of death of both the spouses, the property is equally distributed or divided amongst the surviving members in Goa. So this is how, in effectiveness, this uniform civil code is applicable in Goa. Now, what we need to understand is what needs to be done. What is the way forward? Now, before understanding the way forward, let us understand the perspective of Honorable Supreme Court of India. So, a Supreme Court bench has said that it is interesting to note, whereas the founders of the Constitution of India in Article 44, Part 4 of our Constitution, which deals with directive principles of state policy, has hoped and expected that state shall endeavour for its citizens the uniform civil code throughout the territories of India. Till date, no action has been taken in this regard. That is what Honorable Supreme Court has said. So, Honorable Supreme Court has remarked that in our Indian Constitution, by the Constitution makers, it was written that Uniform Civil Code, in the Directive Principle of State Policy, Article 44, that Uniform Civil Code shall come up in all the territories of India in future. Right? But till date, no action has been taken under this regard. That is what Honorable Supreme Court observed. Now, Honorable Supreme Court, it favors uniform civil code throughout the India as it is envisaged in our DPSPs. And it also cited example of Goa. So, the state where uniform civil code for all is implemented irrespective of the religion and no provision for triple talaq as well. So, also, one more thing is there that Supreme Court has said that no attempt has been made to frame a uniform civil code despite Honorable Supreme Court appeals in the very famous Shah Bano case and Sarla Mutkal cases. So that is what the opinion of Honorable Supreme Court is there under this Uniform Civil Code. So that means Honorable Supreme Court of India and the executive of India currently is also of the opinion that uniform civil code should be there. Now, what is the way forward? The way forward is, yes, we should move towards implementation of a uniform civil code in India, but there should be trust building exercises first amongst the different communities, amongst the different religions, amongst different sections of our society, and also there should be wider consultations in and around this uniform civil code. Plus, there should be codifications with moderation, and the codification with moderation is the need of the hour. That is what the ideal way forward looks like. I hope this is very, very clear to all of you. Now, coming to the third topic of today, that is in relation to multidimensional poverty. Now, in her interim budget speech, our Finance Minister Nirmala Sitharaman has said 25 crore Indians has been pulled out of multidimensional poverty over the past 1 decade, that is over the past 10 years. For 25 crore Indians has been pulled back or pulled out of the multidimensional poverty over the past 1 decade. That is what our Finance Minister Nirmala Sitharaman said in her budget speech. Now, in relation to General Studies Paper 2, issues relating to poverty and hunger has been specifically mentioned. So, it becomes very, very important for us to understand. But first, we need to understand the term that is your multidimensional poverty. What do you mean by the term multidimensional poverty? Now, the term simply says that poverty is not unidimensional. It is not one-dimensional, but it is a multidimensional, that is, it is a multifaceted. Now, traditionally, of course, we believed that lack of food, clothing and shelter would mean that a person is poor. So if a person is not having access to food, not having access to proper housing, and not having access to clothes, that person would be considered poor. But since the needs of the people changed over a period of time, so in modern times the need changed and the definition of poverty also changed. That a person is not having access to education, person not having access to healthcare, that will also be considered poor. But multidimensional poverty says that poverty is not just associated with monetary needs. Poverty is associated with a lot of other factors as well. For example, if a person is not able to fulfill his or her basic capabilities, that means a person is not able to achieve its full potential. If the person is having lack of resources of any form, that person would be considered poor. So it's a multifaceted approach, and if a person is not able to achieve the full potential which they think they can achieve, due to several drawbacks, due to several issues, due to several situations, that person is in a state of poverty. And we see Professor Amartya Sen's capability approach also, it talks about existence of freedoms. So if there is a lack of freedoms, a lack of different freedoms, for example, economic freedom, social freedom, political freedom, cultural freedom, if there are lack of different freedoms in a person's life, that person will be considered poor according to Professor Amartya Sen's capability approach as well. So this means poverty should not be seen with a parochial view, that it is lack of financial resources, but it should be seen in a multifaceted view. That means a lack of a variety of things can constitute the condition of poverty in today's era. Now, since we have understood the concept of multidimensional poverty, let us understand Multidimensional Poverty Index, which has been launched by your UNDP and OPHI, so United Nations Development Programme, and Oxford Poverty and Human Development Initiative. They together combined release an index known as Multidimensional Poverty Index. Now, what are the various indicators under this index? See, there are 3 dimensions of poverty under this Multidimensional Poverty Index of your UNDP and OPHI. First dimension is in relation to healthcare. Second dimension is in relation to education. Third is in relation to standard of living. Now, under healthcare, nutrition of a person and child mortality is seen. Amongst education, years of schooling and school attendance are the indicators. In standard of living, your cooking fuel, sanitation, drinking water, electricity, housing and the number of assets, these all things are taken into account while we are seeing standard of living. And according to the Multidimensional Poverty Index, if any individual or a household is deprived in any of the 3 indicators which have been mentioned here, that is amongst nutrition, child mortality, years of schooling, school attendance, cooking fuel, sanitation, drinking water, electricity, housing and assets, if a person is deprived of any of the 3 indicators out of the 10 indicators which are mentioned here, that person or that individual would be considered as multidimensionally poor. That is what your multidimensional poverty index tells us. Now what we need to see is that in this 2023 global multidimensional poverty index, what has been the performance of India? So this 2023 global multidimensional poverty index, it says that India has lifted 415 million people out of poverty between 2005-6 and 2019-21. 415 million people has been lifted out of multidimensional poverty. That is what your global multidimensional poverty index of 2023 says. And it also says that out of the 25 countries that has halved the global multidimensional poverty values within 15 years, India is one of them. So India is one of these 25 countries which have managed to halve the global multidimensional poverty index values in the 15 years time frame. That is what your global multidimensional poverty index of 2023 says. Now, taking inspiration from this global multidimensional poverty index, India has also launched its own Indian MPI, multidimensional poverty index. It has been launched by your Niti Aayog in the year 2021. And two additional indicators, other three major indicators, and under that 10 sub indicators. Now, adding to that, two more indicators have been added by this Indian multidimensional poverty index by the Niti Aayog. The two additional indicators are, first is maternal health, which is under the health dimension. It is added that maternal health will also be taken into consideration, and also the bank accounts. So amongst the standard of living dimensions, one more thing is added, that is bank accounts. So that is in relation to your multidimensional poverty index in India. Now coming to the last topic of today, that is your maritime piracy. Now the Indian Navy has foiled a piracy attempt on an Iranian flagged fishing vessel FV Omeril off the east coast of Somalia on February 2. Now in this relation, the topic of maritime piracy and what India has been doing in relation to combat of this maritime piracy, this becomes very, very important for us. So in relation to General Studies Paper 3, Security Challenges and Their Management, this maritime piracy becomes very, very important for us. Now, this UNCLOS, that is UN Convention on Law of Seas, 1982, it says, it defines maritime piracy, and it says that when people on private boat or ship commit crimes like kidnapping, violence or robbery for personal gain, that is what you call as maritime piracy. So maritime piracy refers to when people on private boat or ship, they commit illegal activities or criminal activities like kidnapping, like violence or robbery for their own personal gain. That is what we call as maritime piracy. Now, what are the different range of crimes which are associated in this maritime piracy? It can range from petty theft, from ships at seas or anchorage, to armed robbery and hijacking of the ship for a ransom. So all these range of crimes are involved in this maritime piracy. And what are the different threats which maritime piracy poses in front of us? First, of course, is the threat of physical harm, the threat of kidnapping or associated humanitarian concerns. Then there is also a threat of disruption of trade if certain area is targeted or specified as an area full of pirates or full of maritime piracy. Then disruption of trade routes can also be there. And if disruption of trade route is there, of course, trade might decline and economic losses would be suffered. Also, it will impact the fishery industry because fishermen, they would be skeptical of going to areas which have been the areas in which maritime piracy is higher. Environmental risks, so it might lead to various environmental risks. For example, the piracy involving oil theft, it can have the chances of spillage also, and the different pollutants might be released. So that can be a threat to environment also. Then security concerns, definitely. So any countries of shipping vessel or any of the vessel of any of the countries is targeted by the pirates, by a group of pirates, their country's security also comes at a risk. Security concerns are there, and it is also a risk to the global security and global maritime security in general. Okay, now what we need to see is what are the various steps taken by India in this regard. So there are certain operational steps and there are certain multilateral fora which has been set up to combat piracy. So what are the various operational steps? Operational step means that we have deployed various naval ships, various navy ships with armed helicopters which will patrol the piracy prone areas. Specified, okay, these areas are piracy prone areas. There we have designated and deployed naval ships with armed helicopters for their protection. Of course, we are having anti-piracy patrols in Gulf of Aden from October 2008, and it has been continuing since. Regular anti-piracy patrols we are doing. Also, aerial surveillance system by long maritime patrol aircraft and unmanned aerial vehicles, that is UAVs, have also been initiated by India. Also, India participates in a lot of multilateral fora, again to set up policies in relation to combating piracy. So, one such is your RECAP, that is your regional cooperation agreement on combating piracy and armed robbery against ships in Asia, specifically in the Asian region. Then another initiative is RMSI, that is Regional Maritime Security Initiative. Another initiative is IMAC, that is your Navy's Information Management and Analysis Center. Again, it is a center which provides various informations and analysis in relation to these piracy attempts, and especially in these piracy prone areas. Also, the Information Fusion Center for Indian Ocean Region, that is IFCIOR, has also been launched by India, and India is a part of it. So, this tells us that Indian government in general and Indian security forces, they are taking a lot of measures to combat this maritime piracy and to make a maritime world a very secure and a safe place for trade and economic prosperity of all around our country. So this is the end of this topic, and I hope you learned something from this lecture. All the very best to all of you, and do well. Good luck.